Without further ado, it is my pleasure to turn the floor over to your host, Mr. Chad Griffin, Board President of the American Foundation for Equal Rights. Mr. Griffin, the floor is yours.
Thank you, and thanks everyone for joining. I apologize, I have a bit of a holiday cold, so I'm going to be very brief, and what I want to do is introduce the two lawyers, Ted Olson, who all of you know well through this case, as well as Ted Boutros, who is a senior attorney at Gibson, Dunn & Crutcher, and has been a lead attorney with Mr. Olson on this case. Most of you know both of these attorneys well, and without further ado, I will turn it over to Ted Olson to make some brief remarks, and then we will open it to questions, and Ted will take questions after the opening comments.
Thank you, Chad. This is Ted Olson, and Ted, my partner Ted Boutros is on the call with me. I wanted to say preliminarily that David Boyes, our colleague in this case, could not be on this call. He's attending to a very important personal matter that prevented him from being a participant in this call. So Ted Boutros and I will speak for the plaintiffs in this case. And I thought that I would start by just simply making three fundamental points, and then we would respond to your questions. The first point is that the Ninth Circuit Court of Appeals has certified certain questions of California law for resolution by the California Supreme Court in order to assist the Ninth Circuit in determining whether the proponents of Proposition 8 have the legal right to appeal the district court's decision last August declaring that measure, Proposition 8, unconstitutional. We are confident that the California Supreme Court will answer those questions fully and expeditiously, given the vital importance of this case to hundreds of thousands of Californians who are being discriminated against daily by the existence of Proposition 8. Secondly, the district court's decision, to remind everyone, last August found that Proposition 8 violates both the due process and equal protection clauses of the United States Constitution and the rights of all citizens who wish to marry the individual of their choice if that person is of the same sex. The court held that the United States Supreme Court has repeatedly announced that marriage is a fundamental right in America, indeed the most important relation in life, and a matter of liberty, privacy, and freedom of association, fundamental to all of us. That right may not be withdrawn based on a person's sex or sexual orientation, which is what Proposition 8 did. And the court found that denying that right was discriminatory, damaging, and without any rational justification. Third, every day that goes by, Proposition 8 inflicts immeasurable and incalculable damage on California citizens, including thousands of innocent children. Both the Governor and Attorney General of California have agreed that Proposition 8 is discriminatory, destructive, and a violation of the United States Constitution. The plaintiffs in this case and countless Californians have suffered from the effects of Proposition 8 for over 2 years now. It is imperative that this law be stricken down, as the district court held, as soon as possible, and that equality and decency be restored to all California citizens as soon as possible. Now, I think that it's appropriate for us to hear from and attempt to answer your questions.
The floor is now open for questions. If you do have a question, please press the number 7 or the letter Q on your telephone keypad. Questions will be taken in the order they were received. If at any point your question has been answered, you may press 7 or Q again to disable your request. If you are using a speakerphone, we ask that while posing your question, you pick up your handset to provide favorable sound quality. The first question comes from Bob Gelco of the San Francisco Chronicle. Bob?
Yeah. Will you file in the state Supreme Court on this as to whether they should take it up, and if they do, whether they should how they should rule?
Yes, we will accept any opportunity that the rules of the California Supreme Court provide us, and the court rules allow us to provide a response within 20 days of the certification request by the Ninth Circuit. There may be additional briefings. We haven't looked into all of that, but we will supply the court with our views on these questions in an appropriate way.
And just so that I'm clear, the views that you expressed before the Ninth Circuit were that there is no standing, that Supreme Court precedent and California law don't confer standing on proponents of initiatives.
That is correct, Bob. We will make the same arguments and the same points and cite the same authorities that we cited before.
Thanks.
The next question comes from Karen Gullo of Bloomberg News. Karen?
Ted, along those lines, the proponents of Prop 8 say that if it is found that they have no standing, then not only should the appeal be dismissed, but also the lower court, Judge Walker's ruling. What's the plaintiff's position on that?
Well, they're completely wrong about that. And I don't even know where they get that idea. The district court had jurisdiction, heard the case. All of the parties were before them. The proponents of Proposition 8 were given every opportunity to make their arguments, to present witnesses. They basically did not do so. They put on a couple of witnesses, but withdrew most of their witnesses. So there was plenty of jurisdiction, standing, and opportunity to be heard. The court very carefully heard all of their arguments and decided that Proposition 8 was unconstitutional. This court had jurisdiction to make that decision, and it made a decision that was applicable to all officials in the state of California, and that would be the outcome. If there's no appeal permitted by the proponents of Proposition 8, that ruling would stand.
Can you give us any idea of how long the delay on the constitutionality issues is now will undergo, given the standing, or how long will all this take?
Well, we respect the California Supreme Court, which is, of course, familiar with the issues raised by Proposition 8, because those issues were decided initially by the California Supreme Court when it upheld the right of all citizens in California to marry, irrespective of their sexual orientation or their gender. And it looked at Proposition 8 specifically under the California constitutional provisions before. I would expect that the California Supreme Court, especially knowing that the rights of innocent citizens of California are being seriously affected every single day by this discrimination, which the district court has held has been damaging and is without any rational basis whatsoever. I would think that the California Supreme Court would want to render its decision as promptly as possible so that the merits can be resolved expeditiously.
The next question comes from Scott Schaefer of KQED. Scott?
Hi, thank you very much. Ted, as a practical matter, setting aside the discrimination and the damage that you've just described, do you think occurs as a result of Prop 8 remaining in effect, as a practical matter, might there not be a benefit to slowing this down and waiting, giving the Supreme Court a little more time to see how the federal mood on the question of gay marriage? I mean, Joe Biden said the other day the question is evolving. People's attitudes are evolving. I mean, if it slows it down by a year or more, other states may have adopted same-sex marriage. There may be, more of an indication of the country moving in that direction. Do you see any upside to slowing it down, which may be one of the results of this?
Scott, that's a good question, but I think the answer is quite clear that we see no good side whatsoever for requiring citizens in California essentially to drink out of different drinking fountains and go to separate classrooms and to have their most treasured relationships denied to them by the state of California, and for the state of California continue to put a fence around their relationships and tell them that they're not entitled and that they're different. This is, as far as evolution is concerned, I would think that the president and the vice president have had plenty of time to evolve their points of view. They were urging the Congress of the United States just a few weeks ago to eliminate this same discrimination in the military, and they were successful. There's no reason why we have to subject the rights of California citizens, gay and lesbian citizens in California, to a popular referendum in other states or wait for people to recognize how much damage measures such as Proposition 8 are doing. We're anxious to proceed promptly to vindicate those rights.
The next question comes from Jerry Marcon of the Washington Post. Jerry?
Hi. Can you go back, if you don't mind, to the question of what happens if, in the event that the Ninth Circuit panel decides that it does not have standing to hear this appeal? And as a corollary question, and I apologize if this is a dumb question, but can you explain a little bit about the issue of in the previous litigation about how this issue only applies to 2 counties under some earlier California Supreme Court ruling, LA and Alameda County? I didn't quite understand that.
Well, first of all, if the Ninth Circuit, based upon what advice it gets from the California Supreme Court, decides that the proponents do not have standing to appeal, that means that the district court's decision, the district court's 134-page opinion and judgment that holds Proposition 8 unconstitutional is the law of the land as far as the court's jurisdiction is concerned, which was all California. The court rendered a decision against the chief law enforcement officials of California, pronouncing Proposition 8 unconstitutional and directing the governor, the attorney general, and other state officials not further to enforce Proposition 8. We brought an action against Alameda County and Los Angeles County as well, because those were the 2 counties where marriage licenses were denied to the plaintiffs. But as the California Supreme Court has said itself, marriage is a matter of state law and a matter for state enforcement. So as soon as the judge renders a decision, which he did, against the governor and the attorney general of California, that is it as far as all officials in the state of California are concerned. And the district judge specifically said that his order applied to the governor, the attorney general, and all officials acting under their jurisdiction or supervision. So the answer to your question is that the judgment would apply, Proposition 8 would be unconstitutional, and it would apply throughout the state.
Okay, thanks.
The next question comes from Adam Bink of Courage Campaign. Adam?
Hi, thanks for having these conference calls. My question is on Imperial County. I know that the Ninth Circuit said there's no standing. Can the California Supreme Court make a ruling on that judgment, whether or not that was in the question that submits to the California Supreme Court, and could that change the game maybe?
No, the California Supreme Court would only address the questions which were submitted to it by the Ninth Circuit. So that decision having to do with Imperial County is not going to the California Supreme Court, and the California Supreme Court will not address it.
The next question comes from Karen Ocam of Frontiers in LA. Karen?
Thank you, and I second Adam. Thank you for having the conference calls, and hi, Ted. And Ted.
Hi, Karen. How are you?
Good, thank you, sir. So I'm wondering if you could explain a little bit more, and forgive me, I should know all of this by now, but it seems to me in my sort of lay reading of this that the Ninth Circuit seems inclined to grant standing because nobody else is there to defend Prop 8. And I was wondering if you could explain that whole exchange based on that Arizonans for official English versus Arizona, during the trial, the arguments at trial. And that's number one. And number two, if you could respond to what appeared to be kind of a slam at you guys for not doing essentially a class action lawsuit.
Okay, thank you. In the first place, the court mentioned the fact that the Attorney General and the Governor had decided that Proposition 8 was unconstitutional and they were not inclined to defend it. The California Constitution makes the Governor and the Attorney General the chief law enforcement officials of the state of California, whether a measure is in the Constitution or in the state laws and so forth, and they must make judgments with respect to the best interest of the citizens of California, and they may make judgments with respect to the policies of the state of California, and they determined, and the district court agreed, that Proposition 8 was unconstitutional, was damaging to Californians, and they chose not to defend it. That does not mean that anybody can walk along and say, well, they decided because of their official capacity under the Constitution of California to make that judgment that they would step into the shoes of the Governor or Attorney General of California. The Arizonans for official English case was a similar situation where the United States Supreme Court said that there was not standing and they could not imagine that there would be standing for someone that just comes along and decides whether they're a proponent of a measure, whether they're in favor of a measure, whether they've spent money for some measure or something like that, they would like to see it enforced. That does not give them standing. The Supreme Court unanimously suggested that they didn't have any basis for assuming that there would be standing. They didn't directly address this question, but unanimously they cast serious doubt on it. And as to what the court was saying with respect to how we chose to litigate this case, we respectfully disagree with the implication there. We brought an action against the law enforcement officials of the state of California, the officials which the California Supreme Court has said are responsible for the marriage laws of the state of California. In addition, we threw in the two county clerks who had denied certificates or licenses to marry. We didn't even have to do that. And we certainly did not have to bring a class action. There have been many, many cases in the United States Supreme Court, including that Colorado case that you're all familiar with, Romer versus, I guess it's Romer versus Evans, which struck down California's laws that were discriminatory against gay people. You may bring these cases as class actions, but you need not bring them as class actions. And the district court addressed that question and rendered a judgment and an injunction against the state of California, deciding that this constitutional provision was not constitutional under the federal Constitution and could not be enforced, and that, in our judgment, is dispositive.
So did you have the same kind of reading that the Ninth Circuit looks inclined to grant standing, or am I totally off base there? Well,
I think that you are reading between the lines, and I think I'll leave it the way it is. I think that they asked for a resolution of the standing question of the California Supreme Court, and surely they will respect the California Supreme Court's decision with respect to that standing question.
Okay, thank you.
Thanks, Karen.
The next question comes from Lisa Leff of the Associated Press. Lisa?
Happy New Year, everybody. So following up on those excellent questions that came before, I think one of the things that we're all wondering is, let's say the California Supreme Court says, yeah, our reading is in line with that Arizona case and no standing for protect marriage. could the Ninth Circuit, even though they've asked for this guidance from the California Supreme Court, once they get it, if the California Supreme Court says, no, they don't have standing, could the Ninth Circuit somehow find a way to grant standing on its own? That's one part of the question. The other part of it, getting back to the whole question is, if they don't have standing, what becomes of Judge Walker's decision? On page 6 of the order today, there's a footnote number 2, where the panel gives its reading of the kind of the state of play of all that. And instead of saying from the plaintiffs that it's an issue of, it applies statewide, that they're taking, as you've probably seen, a more nuanced idea that, going back to the questions they asked Mr. Boies during oral arguments of whether or not it would apply in those 2 counties and there would be further litigation necessary in order to make it be binding statewide. So if you could address those 2 things, I think that's what a lot of our questions are kind of getting to is, would it, in fact, you've said already a couple times, yes, this would be binding statewide, but the Ninth Circuit seemed to imply otherwise in that footnote. And then also, could the Ninth Circuit go ahead and grant standing on its own, even if they get a different kind of ruling from the California Supreme Court? Sorry for the wordiness of that question.
That's fine, Lisa. Both parts of that are good questions. In the first place, the Ninth Circuit recognized that the proponents would only have standing, if at all, if California law gave them the right to defend Proposition 8 in the shoes of the elected officials of the state of California. They have asked the state of California through the California Supreme Court, does California law give them that kind of standing? The California Supreme Court would be the authoritative voice with respect to what California law requires in that connection or provides in that connection, and the Ninth Circuit would be bound by that. I can't imagine that the Ninth Circuit, having asked that question of the California Supreme Court, acknowledging that it was a matter of California law, would then ignore the California Supreme Court on that question. I don't think they could, and I don't think they wouldn't. With respect to the statewide application of Judge Walker's order, it is quite clear in my mind. There was some confusion during the oral argument because of the way the questions came and the way they were addressed and having to do with county clerks and all of those issues and who was a deputy clerk and who was not a deputy clerk. Pardon me?
No, I'm agreeing with you.
Yes, and so some confusion may have crept into the record, but we have gone back repeatedly and we've gone over our same tracks, but we've looked at Brown versus Board of Education. We've looked at the Loving versus Virginia case, which was the marriage case having to do with interracial marriages. We've looked at the case in which the United States Supreme Court decided the rights of marriage of people who were in prison, and on and on and on. Brown versus Board of Education involving racial discrimination, cases under the Due Process Clause, cases under the Equal Protection Clause. And if you bring an action against the elected officials of the state of California or any other state that have dispositive responsibility to enforce the laws of that state, and a federal district court with jurisdiction enters a declaratory judgment that the measure is unconstitutional and applies that judgment against the responsible officials for the state of California, especially in the context where the California Supreme Court has specifically said in an earlier case that marriage is a matter of state law, not of local or municipal responsibility. That covers it. That's dispositive as far as the entire state is concerned.
And, thank you for the clarification.
And Lisa, this is Ted Boutros. Just to add to that, in state court, you can sue the whole state. You can sue the state of California. That's what happened in the marriage cases. They didn't sue every county clerk, and the California Supreme Court found there was a fundamental right to marry, and it applied statewide. In federal court, you have to file, because of the federal constitutional rules, the government officials who represent the state in this context, and that is the Attorney General and the Governor, and that's why we sued them, and a ruling against them binds the state itself in terms of enforcing that law.
I know we talked over much never even thought to ask the question again until the Ninth Circuit brought it up, or some of the judges brought it up during the oral arguments. It hadn't even occurred to me that it could be otherwise. So thank you for the clarification.
Sure.
The next question comes from Matthew Bacco from Bay Area Reporter. Matthew?
Hi. I just have two quick questions here. One is, how unusual is it for a federal panel to seek guidance from a state court like this? And secondly, considering we have a new presiding justice on the Supreme Court, and what impact do you think she'll have on how this plays out?
Well, answering your first question, Matthew, first of all, it doesn't happen very often, but it is not at all unusual. It's provided for in the federal rules that when a question of state law comes before a federal court and the federal court is at all uncertain as to what state law, if state law is in fact going to be dispositive as to certain parts of the issues or certain parts of the case, that the federal court may do that. And so it happens all of the time, although it is very seldom an issue that comes up in federal court. So it's not unusual, but it does not happen very often. And you ask also about what impact there would be potentially, because there's a new Chief Justice of California. I don't think that there would be any impact by that. We have very, very strong precedents that support our views with respect to the standing question. The California Supreme Court is very, very experienced with respect to what California law applies, and this is a talented and highly competent new Chief Justice, and we don't think there would be any difference as a result of Chief Justice Ron George leaving the court.
Okay, thank you very much.
The next question comes from Sunavi Briban. Sunavi?
Hi. I've got a question kind of following along what you mentioned, Mr. Olson, about Walker's ruling becoming the law of the land. If the California Supreme Court finds that the Protect Marriage people don't have standing, that, as you said, that would obviously mean that Walker's ruling would be the law of the land. However, would that limit the scope of what you could possibly achieve were this case to reach the Supreme Court?
Well, if the California Supreme Court decides that the proponents do not have standing, I think that is the predicate of your question, then this appeal would be dismissed. Chief Judge Walker's decision would be, the law of the land would be the law of the state of California, because it strikes down Proposition 8. There would not be then any appeal to the United States Supreme Court, except the proponents could appeal the standing decision. And I suppose that case could go to the Supreme Court, and I don't know whether it would or not. But it would essentially, other than an appeal on the standing question, it would end the issue as far as California is concerned, and the agony that hundreds of thousands of California gay and lesbian citizens are experiencing every single day in their lives would finally be brought to an end. As I said at the beginning, this Proposition 8 has been in effect for 2 years now. The Chief Judge Walker recounted the damage that's being done to gay and lesbian individuals in California, the children of gay and lesbian individuals, to other Californians, because their Constitution permits discrimination on the basis of sexual orientation. Finally, that damage and that agony would be over with, and we hope that will happen soon.
And I would add, this is Ted Boutros, that we've made clear, our foundation has made clear, and our legal team has made clear that we brought this case to get the broadest possible ruling and protect the rights of as many people as possible in the United States. And if we win on standing and eradicate Proposition 8, then we're going to look for other opportunities in other jurisdictions to protect the rights of gay men and lesbians in this country and give them marriage equality.
Thank you. Thank you very much, everyone, for participating. I know that some of you have emailed some follow-up questions, and you know how to reach us here at the American Foundation for Equal Rights. And our journey continues, and if any of you need any further follow-up information, you know how to reach us at the Foundation office, and any of the Foundation team members will be responsive. And thank you, Ted and Ted, for your participation.
Well, we thank everybody for participating in the call and caring so much about this issue.
Thanks, everyone.
Thank you.
Bye.